Member for Fong Lim.
Thank you, Madam Speaker. It's a pleasure to speak on an omnibus bill. We haven't had many of them in here for a while, and as we all know, it's often the case that they're a bit of a mixed bag. There can often be little things snuck into them as red herrings, but I'm pleased to report on this occasion that I think that this is a fairly sensible bill covering off a bunch of sensible things that need to be done to tighten up small parts of our legal edifice. I'm encouraged by the words of the member for Daly and the sentiment that legislation should never be completely static, or perhaps it shouldn't be completely immutable. Things change, things need to be adapted, we need to modernise with the times. And that is what is reflected in this bill here, a recognition of the fact that in some instances our legislative frameworks, our administrative frameworks, have simply not kept pace with the modern day. And so what we're seeking to do here, on the advice of the Public Service, the Attorney General's Department, practitioners within the field, is to tidy up a range of small matters, but all of which in totality have a cumulative effect of being able to improve the rigour within our legal systems. Now, as to the matter of legislative scrutiny, as I alluded to in the last sittings, on the Thursday of the last sittings, there is much to be said about how scrutiny committees can function, should function, do function, and later this week I expect to speak at some length about the Scrutiny of Legislation conference that was held in Melbourne at the end of last year, which coincidentally both the member for Daly and I attended, at which we learnt an awful lot about how we could move forward in that space. What we have right now, which is positive though, is a legislative scrutiny committee where the preceding government sought fit to completely abandon the prospect of having one. And that legislative scrutiny committee was referred this omnibus bill. And sadly, there was only one submission, or perhaps fortuitously there was only one submission. The fact being that there was only one submission. And the submission that was made by 𝙍𝙀𝙇𝙀𝙑 was a considered one and raised reasonable points for debate, but not ones, I think, that are so profound that they would warrant objecting to this bill in any form or necessarily considering any substantive amendment to it. 𝙍𝙀𝙇𝙀𝙑 does great work. I've known a lot of people that have worked there for a long time, and I will certainly defend them to the hilt. But I think it's fair to say they err on the side of being cautious when it comes to protecting civil liberties, and they urge on the side of caution when it comes to making sure that we don't accidentally run roughshod over rights and regulations and responsibilities. And in that regard, I understand the concerns that they raised in their submission. I presume everyone in this House obviously has read the 𝙍𝙀𝙇𝙀𝙑 submission to the Legislative Scrutiny Committee on this omnibus bill, which I know you're all very excited about. And, you know, having read it, I don't, having had plenty of experience with NTCAT myself, necessarily think that we are messing with NTCAT in a way that is going to be deleterious to our legal system. In actual fact, it is the case, and it has been the case in this jurisdiction for some time, that NTCAT has been overwhelmed and swamped by people who have been essentially putting in, if not vexatious, speculative litigation claims or statements of claim. And so something to be done in that space to be able to clarify and codify that in actual fact costs orders can be recovered and that there is a minimum price of entry, as it were, to tango with NTCAT, I don't think is a terribly bad thing. I think it actually will improve efficiency in that space. I welcome a robust judiciary and an accessible judiciary, but certainly I don't want to set one up to fail by overwhelming it with, essentially vexatious claims. So again, I'm encouraged by the support evidence for the bill in broad brushstrokes by the Labor opposition and by the tone of the member for Daly's statement, which is constructive. Legislation shouldn't be static, and we need to be consultative, which we were in this case. We provided an opportunity for people to make submissions to the Legislative Scrutiny Committee, and we have considered, the committee rather, the Legislative Scrutiny Committee, will have considered that, and having read the report back, they have no axe to grind with the findings of the committee, with the bill. What we are doing here in some ways is the equivalent of clearing the weeds out the back of the garden. It's not very sexy work, but it needs to be done. Periodically, the garden gets messy out the back, and you have a raft of laws, regulations, rules that simply are not maintained. And if you don't maintain those things, your garden goes to pot, and as I'm finding out at the moment, your reticulation system is busted because you didn't weed. And so it's important that we do this kind of work. And again, I commend the Attorney-General on having referred to the Legal and Constitutional Affairs Committee a referral to review all regulations in the Northern Territory Statute Book that predate 1990 and back, because it is important for us to do that work, to clear the back of the garden, to find out what is fit for purpose, to find out which departments have processes in place to make sure that their statute books, their regulations, their procedures are still modern, fit for purpose, able to serve us in the Northern Territory. And that review is proceeding in earnest. It still has a long way to go, but without wanting to be too pointed, the reason we're doing that review in no small part is because nobody's really done that gardening out the back of the weeding out the back of the garden for a while. So, you know, a lot of these little fixes, I'm sorry to say, the last government didn't do a very good job of keeping the garden tidy out the back, and so that is why, well,
Okay, stop the interjections.
All I will say.
Through the Speaker, please.
Thank you, Madam Speaker. Madam Speaker, unfortunately, I can't draw attention to members of the House that are absent, but I'm sure that all former Attorney-Generals of the Northern Territory would speak to the fact that we could have done more to maintain the weeds out the back of the garden over the very many years that have passed. In any case, this is part of the government's commitment to tidying up, modernising, and if you're talking about action and certainty and all that kind of good stuff as well, part of it is about making sure you don't have superfluous things hanging around your statute books and around your systems. And that is why we have the Omnibus Bill before us today with a range of different items, all of which do something to improve our administrative frameworks within the Northern Territory. So to the substantive items on the agenda, encouraging that the healthcare decision-making delegation has the support of the government, first of all. It's a sensitive area intersecting with guardianship. It's a sensitive area intersecting with difficult decisions that need to be made by a single senior practitioner at the moment who has delegated authority. And these are important decisions. There's a reason why somebody is prescribed to take on these jobs at the moment, and it's not just carte blanche for anyone to do it. But again, what's being proposed here is something that will help us create efficiency within the healthcare system by providing the senior practitioner the opportunity to be able to provide delegated authority to, as I understand it, a couple of people who are currently earmarked as being able to take some of that pressure off. Remember, healthcare systems don't just require healthcare clinicians, they require healthcare administrators, they require healthcare infrastructure and systems. And so this is about improving that systemic background and setup. So I'm encouraged, as I say, that we're not having an unnecessary debate about, you know, coercion, public guardianship, control powers and all that sort of thing. As I said, there are currently 2 people who've been deemed appropriate, as I understand, within the healthcare system to which this authority could be delegated, and that will take a considerable amount of pressure off the system from a single person who, at the moment, if not operating as a bottleneck, certainly is overwhelmed by their responsibility in isolation. So that one's a positive one. So then let's move on to the Justice of the Peaces and the Commissioners for Oaths. Now again, this is a government that is priding itself on reducing red tape and creating regulatory efficiency, I'm sorry. bit tongue-tied still from the flu. My apologies. And so it would seem counterintuitive at some level that we might be prescribing that all people who are commissioners for oaths, all people who are justices of the peace, should require police checks as a mandated provision now, because this bill locks in the requirement for a national police check for anyone applying for those roles. But it's important to realise that not everyone applies for those roles. There are also a range of people who have these roles ex officio, including, I might add, all of you within this chamber. As the member for Karama, I think the member for Karama probably uses his Commissioner of the Oath stamp more than anyone I know. We wouldn't want to slow down his hard work. And it's important that we have Commissioners of the Oaths on the books, and it's important that we have Justices of Peace on the books, and Justices of the Peace on the books, and enough of them. And quite honestly, we probably could do with more of them, but we want to make sure that we have the right people also doing those jobs. And so at the moment, essentially, this is codifying what is already practice in the Attorney General's Department, which is to check that fit and proper persons are doing these jobs. But this will not be, I think, a new administrative burden. I think it will add integrity to ensuring that people who do certified documents and witness documents are all fit and proper persons to do so. So again, encouraged that we have the tick of approval from the opposition in this regard. Modern conveyancing, land titles and property transactions. Now, anyone who's attempted to purchase property in the recent past will know how nightmarish it is in this jurisdiction relative to anywhere else pretty much, because of the fact that almost nothing is done electronically. Well, not nothing, but a lot of things that are done electronically elsewhere are done on an abacus and stone tablets in this jurisdiction at this point. I jest. Obviously, it is, though, a step forward for us to be moving towards a modern conveyancing framework where we use e-conveyancing more to do land title transactions online rather than simply paper titles. And this is actually a genuine modernisation step, and it does actually improve the, it reduces the friction within the property market. It's actually a significant point. There are studies about how when you make it easier to buy stuff, people buy stuff, and when you make it harder to buy stuff, a lot of the time they become frustrated out of the process. Now, in the ordinary course of events, people don't abandon property purchases because it's a massive pain dealing with conveyances and paper. It just means it takes a lot more time, it takes more cost, and it slows down the fluidity of that system. And so what we are doing here is something that is actually genuinely long overdue. I've been hearing about it happening in this place for a long time, and I'm actually surprised, to be honest, that no one has taken the bull by the horns on this issue previously. As I say, I think potentially, the former government was more concerned about the front lawn looking good than weeding out the back garden. Anyway, the point is we're doing the gardening work now, and this is an important part of the edifice for us to tackle. I will say, because it's a legitimate concern that's raised from time to time, electronic titling does enhance Torrens title systems by making it faster, cheaper and more integrated, and maintaining government-owned certainty, of course, of ownership, government-backed certainty. But there are risks, and those are well identified, and it's good to put them on the record. Whenever you introduce electronic systems, there's a transitional period where you have to think about cybersecurity, accessibility concerns, technical vulnerabilities that have to be carefully managed through robust digital infrastructure, legislation, and of course, maintaining public trust. I'm convinced, based on my briefings with the Department of the Attorney General, that those things are all being accommodated, and what we're doing here is shifting from a must to a may situation to provide flexibility in a transitional mechanism so that we can incrementally move towards a digitised system. But there is no necessity to impose that. So for the older, property investor out there who is still used to doing things by paper and knows their way around the system inside out, there will still be transitional mechanisms and times to work. But, for newer people moving into our marketplace, which is an increasing number of people, we all hope, in keeping with incentivising housing supply in this jurisdiction, this will hopefully make things easier. A lot of people want to be able to DIY, and quite honestly, it's pretty much impossible without digital conveyancing systems in place to be able to give effect to that mechanism. So again, I encourage the fact that that is happening. older people, I guess, are the ones to be really mindful of in relation to transitioning to new technologies. And so we're trying to make sure that we mitigate any of those things by making sure that people in remote areas or older people understand the digital systems and the transitions away from paper titles. So yeah, but in any case, it's almost impossible to purchase a property, obviously, without a conveyancer. But at least now this provides you the option to move in that direction with the passage of time. So that is a positive development as well. Madam Speaker, if you just bear with me for 1 second. I just lost part of my speech there, my apologies. Yes, so the Legal Professional Act then, which is the next part of the Omnibus Bill. The Legal Professional Act amendments here are also fairly sensible to bring us in line with solicitor conduct rules. I'm all for things that bring us up to code and up to standard with the rest of the country. And this is an area where the legal profession has pushed for some of these changes, and that we recognise that they're sensible changes to be made. You know, we have to go through a long process at the moment to adopt national rules that already work pretty well elsewhere, and this will bring the NT into line with uniform rules and improve processes and push us towards a best practice environment, which is, I think, what we're seeking to do in this space. So again, uncontroversial, and greatly appreciate the support from the government on this issue. Synthetic medicines are probably the headline item in this omnibus bill, and you know, rightly so, because they're a significant issue. And it's important to understand that this is pretty well thought through here. I'm not going to go into a long lecture series on the dangers of fentanyl. Fentanyl has its place within modern medical systems, but obviously increasingly it is a dangerous drug that is starting to infiltrate recreational drug use, and the consequences are significant, severe, and not to be messed with. And that's precisely why what we're seeking to do here is make fentanyl a Schedule 1 item with a situation where you will have trafficable and commercial quantities for prescribed drugs being commensurate with other Schedule 1 drugs, and that makes perfect sense to pretty much everyone operating in and around this space. Sometimes there can be confusion when talking about misuse of drugs, and particularly in relation to these kind of things, where we're worried about a single kid at Base in the Grass being caught with a pill in their pocket and then ending up with a mandatory 25-year sentence. That's not what's going to happen here. What this is going to do is let people who are trafficking in drugs be on notice that they're now trafficking a prescribed Schedule 1 substance and taking a significant risk if they choose to do so. And so it is entirely sensible that we are adding fentanyl to the Schedule 1 and taking it from Schedule 2, and that we are making trafficable and commercial quantities the same as they are for other Schedule 1 drugs. As I say, the safeguard here is that the police and a prosecution would still need to establish intent of sale and supply, and would need additional indicia if somebody was supplying multiple pills, you know, if somebody was to be prosecuted for example, being at an event and having recreational drugs in their pocket. So what we're doing here is trying to prevent harm, and it's a sensible amendment, and again, has the support of the opposition for that reason, one imagines. Continuous improvement is the object of the exercise here of the legal system, of our administrative systems, and I won't be any more pointed in my critique of what Labor has or hasn't done in and around legislative reform and maintaining, you know, regulations that are fit for purpose. I've said enough on that, and we will be coming back to that in due course over time in any case. But as to the matters that are objected to, I note they're not really strong objections so much as legitimate inquiries is how I would put them. And I think that on the issue pertaining to NT-CAT, I don't think it's unreasonable for us to move to the situation where, at a time when we know that NT-CAT is extraordinarily stretched, that we would make it clear and definitive that costs are recoverable in that jurisdiction and in that forum, I apologise. And, you know, it doesn't prohibit people from initiating action in NTCAT. The bar for entry is still comparatively very low in every regard, not just financially, but in terms of even the paperwork that's required to be put into that forum. So I think that the changes are fine. If I thought that they weren't, I would suggest perhaps amending in that space. But as I say, NARJA fulfills a very valuable role in the Northern Territory. It has for a long time, notwithstanding that it has had some complex governance problems over a period of time now, unfortunately. And I respect the submission that they've made, but I also recognise that on the balance of probabilities, these are reasonable changes to make, to codify in the NTCAT space. We are trying to stop vexatious litigation, and everything we do to shut that down, every small signal we put in place, improves certainty within this jurisdiction. And so I want for a robust judiciary, I want for a strong separation of powers, I want for there to be checks on executive power, and I want for people to be able to access the justice system, but I want them to be able to do it on reasonable terms. And so in that regard, I think we're making the right call there. So the final part of this then is the residential tenancies amendments, and I think it's probably here where I must most defer to the guidance and expertise of the Attorney-General, because the decision to make the amendment in this area is really one that sits with the Cabinet and to which I'm not entirely privy. But on the face of it, it seems entirely sensible to me. I think it's probably the case that over a period of time now, we've probably set the public housing system up to fail on a range of metrics, and this is potentially another area where that might be the case, where we're essentially asking them to fail by having to maintain compliance with an administrative regulation that is simply unreasonable in that space. But I imagine that the Attorney-General will speak to that matter, having been asked to comment on it by the member for Daly. Madam Speaker, these bills are not, you know, they're not as sexy and exciting as many other bills, but I think they're every bit as important. And I commend the huge amount of work that would have been done by the people in the background in this space, because every one of these small legal changes can have a knock-on effect. Small legal changes in one place can interact with small legal changes in another place, and they can interact and intersect to the point where you can create unintended consequences. Again, on the balance of probabilities, I see no real reason why we are going to accidentally trigger some harm by passing this law with minimum fuss. It's worth reflecting on just how many acts are covered in this law. I mean, this has intersections with the Anti-Discrimination Act of 1992, with the Domestic and Family Violence Act 2007, with the Healthcare Decision-Making Act 2023, the Justices of the Peace Act 91, the Oaths, Affidavits and Declarations Act 2010, the Local Court Criminal Procedure Act 1928, the NTCAT 2014 Act, the Tribunal Regulations for NTCAT from 2014, Residential Tenancies Act 1999, Sentencing Act 1995, Victims of Crime Assistance Act 2006, and there are others as well. I read that list out because I think it's important for everyone in the House to appreciate just how much work has gone into this, just how many people will have had to look at this many laws to figure out how they intersect and how and when we can make these fixes. And so, you know, I think it's encouraging that the Attorney-General and her team have been able to pull together all these changes into an omnibus bill. It's my hope that we'll see more bills like this into the future in a number of spaces where we could in fact engage in direct regulatory reform. One of the areas that we talk about a lot, but tangentially, is alcohol reform. One of the areas that comes up you know, on a near-to-daily basis when we're in sittings is domestic violence. There are things within the healthcare sector. There are innumerable areas where we could be looking at small fixes in legislation to be able to improve regulatory efficiency without abrogating rights. And I would encourage, in fact, members of the House to consider offering up those small things, because sometimes an entire bill is an enormous undertaking. I mean, an entire bill is an enormous undertaking. But when we can identify small, specific problems, there is precedent around the world for parliaments filled with people of many different stripes being able to bring those forward to the government of the day and say, I have identified in this law this small thing that could be fixed with minimum fuss. Can you throw us a bone here? And everybody gets a win out of it. Most importantly, the people of the Northern Territory get a win out of it when we improve regulatory efficiency. If we are, in fact, to improve certainty, security, decision-making, essentially, that people can rely upon, then you need to have robust systems in place, and you need to, you need to do the remedial work of clearing things out from time to time as well. And so it's extremely important that we do that, and I would encourage especially the crossbenchers to think constructively about how they could offer to the government suggestions on small things that we might all collectively work on together. And of course, the same offer is extended to the actual opposition. There is not too much more I'd like to say, other than to say that there has been fairly extensive consultation on this bill, and I don't really think that anyone can fairly say that we didn't ask for consultation on this bill. The consultation occurred, of course, with the Attorney General's Department, but also with the Health Department, with NTCAT, with some of the independent officers, with OPC, the Office of the Parliamentary Counsel. And so, this is probably one of the best considered pieces of legislation that I've seen come through for a while. And I think that it will do good in its totality, albeit in small ways, but in significant ways nonetheless. And for all of those reasons, I commend the bill to the House, Madam Speaker, and I look forward to this being passed, touch wood, on the voices. Thank you, Madam Speaker.